La emisión está comenzando. Todos los asistentes están en modo de solo escucha.
Hello, everyone. Good morning, good afternoon. On behalf of the MBSAF Forum, it's a pleasure to have you all here with us today. I want to welcome you all to our webinar series on human rights and the environment. I'm Eva Gurria with the MBSAF Forum and the United Nations Development Program team. Thank you for attending today's session on human rights in the context of the CBD post-2020 strategic plan. Today, I will help facilitate this session together with my colleague Diego Ochoa from the MBSAF Foreign team, who will provide technical support. Thank you, Diego. Today's webinar focuses on human rights in the context of the biodiversity agenda, using principles and approaches elaborated in the UN Commission on Human Rights report. Today's speakers will explore links to the CBD Secretariat ecosystems approach, as well as their access to genetic resources and benefit sharing programs of work, and share information on ongoing discussions to develop the CBD's post-2020 strategic plan. For today's webinar, we have an inspiring group of speakers. And I'd like to introduce Dr. Balakrishna Pisupati, organizer and moderator of today's webinar. Dr. Balakrishna Pisupati is an internationally renowned conservation and development specialist with close to 3 decades of experience working at national, regional, and international levels. He was Vice Chancellor of the Transdisciplinary University in India, Chief of Biodiversity at UN Environment, Senior Policy Fellow of Fridtjof Nansen Institute, Chairman of the National Biodiversity Authority in India, Coordinator of the Biodiplomacy Program at the United Nations University, Head of the Regional Biodiversity Program for Asia at IUCN, and Head of Biodiversity and Biotechnology Program at the M.S. Swaminathan Research Foundation. So a long history of achievements. He has advised more than 30 countries on conservation and development policy and served as advisor to international bodies such as the China Council for International Cooperation on Environment and Development, the Global Environment Facility, the World Bank, the United Nations Development Program, among others. Dr. Pisupati is currently the chairperson of the Forum for Law, Environment, Development, and Governance, known as FLEDGE, based in India. So we're very privileged to have Dr. Pisupati leading on all these human rights and the environment webinars in the series. Now, before I hand over the microphone to Bala, who will introduce today's speakers, I'd like to address some of the logistics of today's webinar. We will have up to 2 hours for the webinar, and after the presentations, we will proceed with a question and answer session that I will facilitate. To make your questions, please write them on the chat box in the control panel in your screens. You can also ask the question by clicking on the hand icon in the control panel on your screen. We will then proceed to open your mic so you can ask your questions. I encourage you all to think of your questions as you hear the presentations, and you can even begin writing your questions while speakers are speaking. Unless we open your mics, all attendees, except for speakers, will be in listening mode only. This reduces interference and facilitates communication. Also, as many of our participants are not native English speakers, myself included, I would like to remind speakers of the importance of speaking slowly and clearly. Lastly, this session is recorded and it will be available at the MBSAF Forum website, that is mbsatforum.net. And also all of the participants of today's webinar will receive an email with a link to watch it, as well as a PDF copy of the presentations and some additional reading material shared by Dr. Pisupati. Without further ado, Bala, You have the microphone, and everyone enjoy the session.
Thank you very much, Eva. Good morning, good afternoon, good evening, colleagues who joined us for the third and the last in a session of 3 webinars focusing on the issue of human rights, environment, and biodiversity. As he was mentioning, this particular webinar series is a collaborative effort between UN Environment, UN Development Program, the Secretariat to the Convention on Biological Diversity, SwedBio at the Stockholm Resilience Center. And we are very grateful to all our speakers who have joined us, including Dr. Elisa Mogera and Dr. Harry Jonas, who will be speaking to us today. But we did have had 2 earlier sessions focusing on the issue of human rights, environment, and biodiversity. And what I'd like to do in the next less than 5 minutes is to provide you a bit of an overview on why we are organizing this webinar series, what the webinar series covered so far, and a few key points that emerged from the last 2 webinar series. Many of you are aware of the links between human rights and environment, which has been there with us since the time the UN Charter has been defined. But increasing attention on the links between human rights, environment, biodiversity, and climate change has been happening in the last few years thanks to the efforts of the United Nations, who actually appointed a special rapporteur with terms of reference to focus on the issue of human rights and environment more specifically, who did focus on the issue of links to climate change and also biodiversity, Professor John Knox. You are going to listen to some of the outcomes or the key elements of what the Special Rapporteur's report did say about the issue of human rights and biodiversity through the presentations. But the intent of organizing this series of seminars is not just to look at the key outcomes of the discussions and the report of the Special Rapporteur, but also to begin getting interest from different stakeholder groups to focus on the issue of environment and human rights in general, but more specifically in the context of the Convention on Biological Diversity, or CBD. And for those of you who follow the convention process, you're all aware that currently we are implementing the strategic plan of the convention for the period 2011 to 2020. That includes a set of 20 targets, popularly called the Aichi biodiversity targets, that needs to be achieved by the year 2020. And for those of you who follow the debates and discussions under the convention, not only are aware of the progress that countries are making towards achieving these targets, but also are aware that the Convention Secretariat had already put in place a process to define the next round of the strategic plan for the convention for the period 2021 to 2030, but that needs to be confirmed. So in other words, countries, stakeholders, experts, academicians who are working on the issue of biodiversity conservation will spend the next several months between now and 2020 to define the next iteration of the CBD strategic plan, as well as come up with some ideas on how to deal with the future targets for achieving biodiversity conservation, sustainable use, access, and benefit sharing, all in the context of sustainable development and poverty alleviation. So we thought it is time for us to start focusing on the issue of the convention, its forthcoming strategic plan, which is more popularly referred to as the post-2020 plan. And many of you who again are following the process are aware that several institutions, several initiatives, several discussion groups are already trying to get active in terms of providing inputs into the process. So what this particular webinar series would do or the intent of the webinar series is to focus on a few of key elements that are relevant to our discussions on biodiversity, human rights, and environment. First, during the first session of the webinar, we had an overview on human rights and its links to environment and biodiversity. We also had a reflection on the report of the Special Rapporteur, and this reflection will continue to happen during this particular webinar also. I'm sure both Professor Mogera and Dr. Jonas will be speaking elements of the report relevant to our discussions today. Look at the linkages between the issues of rights-based approaches to conservation and sustainable development, the business perspectives on human rights and environment and biodiversity. Our second webinar specifically focused on the issue of human rights, business, and biodiversity. Also look at the links with issues under the Convention on Biological Diversity, not just restricted, but including the issues of traditional knowledge, indigenous and local communities, ecosystem approach, and others, so that the discussions and the outcomes of these could feed as input into the discussions for further negotiations in developing the post-2020 global biodiversity strategy and the related targets. And lastly and importantly, to look at how these discussions can also strengthen country-led SDG implementation on not just SDG 16 that looks at access to justice, but also on other related SDGs to use the rights-based approaches for development. So I have one slide each to give you a quick overview of what we discussed in the earlier webinar series. The first webinar that looked at the overview on environment, human rights, biodiversity looked at a historical perspective, starting from the UN Charter to key points of the UN Special Rapporteur's report. We discussed a bit on understanding the procedural and substantive rights. We did have much of an elaboration of this, both in the Rapporteur's report, as well as the presentation that was given as a first webinar. We also looked at links with key multilateral processes, including the conventions. We looked at different approaches that are being followed on the linkages between human rights, biodiversity, and environment. There was some focus on key sectoral issues as examples, focusing on food and nutritional security, health, access to ecosystem goods and services, traditional knowledge, and economic development. We wrapped up that particular webinar with a presentation on links between SDG 16 on access to justice and human rights law. And during the presentations, colleagues did cite quite a few examples relevant to the presentations, as well as a set of case studies. The subsequent seminars, webinar number 2, focused on the issue of human rights, business, and environment, where the focus of the presentations were looking at state duties on human rights and business, the work that is currently being undertaken under the UN Global Compact in the context of Sustainable Development Goals, specific focus on SDG 17 and human rights, focusing on the issue of partnerships. We did have a presentation on business, biodiversity, ecosystem services, and human rights. A few examples specifically coming from the mining industry, and the session was wrapped up with a few examples on environmental impact assessments and human rights principles. So with those two behind us, the third webinar is where we are currently at, where this webinar will focus on the issue of human rights in the context of the Convention's post-2020 framework, cite some experiences from the ground, look at the role of indigenous people and local communities in dealing with human rights dimension, what could be the potential ideas for moving forward the CBD agenda, and how is that we can be beginning to prepare ourselves for the 2020 process, the post-2020 process. So that actually gives you a bit of an overview of where we are. This particular session was to be moderated by Dr. Timothy Hodges, who is a practice professor at McGill University. Unfortunately, he had a small injury yesterday, so he could not join us. He's profusely apologizing for his absence here today. So I'll be facilitating or moderating this particular session. Before we pass on the microphone to our first presenter, I'd like to introduce two of our presenters today. Professor Elisa Moguera, who is a professor of global environmental law and director of the Strathclyde Centre for Environmental Law and Governance at Strathclyde University Law School in Glasgow, UK. She is the principal investigator for the research project Benelux that focuses on benefit sharing for an equitable transition to green economy, looking at the role of law, and also facilitates the Marine Benefits Project, where the focus is on sharing benefits from sustainable fisheries, global to local legal approaches to marine ecosystems. She has published widely in the area of human rights and biodiversity, and more specifically, her interest is on the issue of ecosystem approach, which is a major agenda under the Convention on Biological Diversity. I'd like to thank Professor Elisa Moguera for finding time and taking time off from her busy schedule to be with us, and I'm sure we all will benefit from her presentation. She'll be followed by Mr. Harry Jonas, who is an international lawyer based in Sabah in Malaysia. He founded Natural Justice in 2007, and many of us are familiar with Natural Justice and its work, and is now currently working hard to launch yet another initiative called the Future Law, which is a think tank promoting legal innovations and identifying the nexus of social and ecological systems. He co-chairs the World Commission on Protected Areas of IUCN on effective area-based conservation, and is also an active member of the Commission on Environmental Law and the Commission on Economics and Social Policy of IUCN. He's also an Ashoka Fellow. So again, I'd like to thank Harry for joining us, and many of you are aware of the publication Natural Justice have already put, looking at the issue of human rights in the context of post-2020 process. So with that, I pass on the microphone to Professor Elisa Moguera to begin her presentation. Thank you very much.
Hello, everybody, and thank you very much to the organizers for the opportunity to share and exchange ideas about the role of human rights in the context of the post-2020 biodiversity framework. As Bala kindly introduced me, I'm an international environmental lawyer. I'm based at the university, so I will present mainly from a research perspective, but with ideas that also arise from my personal participation in the CBD process as an observer, as a consultant to the Secretariat, as well as a person that has exchanged views with NGOs and national delegations and other groups of stakeholders over the past 10 years or a bit more. What I plan to do is first give a bit of background about the research I've been carrying out in the last 4 years, and show how that already gives some indications about the importance and the vitality of the link between human rights and the Convention on Biological Diversity. I will then recap some features of the current international debate on human rights and the environment that have been discussed in previous webinars, and that I think provide important pointers for us to think about the future of the Convention on Biological Diversity, but also the future of global biodiversity cooperation and policy. And finally, I will try and make those reflections more concrete, and really thinking specifically about how the current effort under the CBD to mainstream biodiversity in the context of the 2030 Agenda on Sustainable Development has so much relevance for our reflection on human rights, and how in particular we may think about the relevance of human rights in the context of work on sustainable use of biological diversity and biological resources. And I understand that my colleague Harry will focus more on conservation, so there may be a couple of references to conservation, but I'll leave that issue for him to treat more in more detail. So as I was saying, my reflections really come from 4 years of research that I have conducted with other colleagues at the University of Strathclyde, both on the books, but also in the field, thanks also to cooperation with Natural Justice, and really looking at a particular element of the convention, the notion of fair and equitable benefit sharing, and seeing how that element has also found more and more relevance in other areas of international law, particularly human rights, but also in relation to the law of the sea, climate change, fresh water, and land. And what has been interesting in this process is that we started off, with a focus on a very niche issue in relation to the convention, and we realized that our findings were pointing at the broader relevance of the convention for international human rights law. So, as many of you are familiar with the CBD process are aware, we almost never talk of human rights explicitly under the convention. There may be references in the negotiations, but usually the outcomes of those negotiations, the CBD COP decision, don't use explicit human rights language. And the convention itself does not have reference to human rights. And one of the interesting outcome of our research was finding out that outside of the CBD framework, in other international processes, including international human rights processes, but also other, the CBD COP decisions were used and considered helpful to interpret human rights obligations in the context of environmental governance processes. So what that means is, even if we may not engage explicitly with human rights, that does not mean that the convention hasn't already provided helpful approaches to look at biodiversity and human rights issues in synergy and with a way to ensure mutual supportiveness. And in fact, what our research has also revealed is that there is much more scope for that cross-fertilization between international biodiversity law and international human rights law. We know that a lot of attention has been paid to indigenous peoples and local communities, and quite a lot of attention has focused on benefit sharing as part of the third objective of the convention on access to genetic resources and traditional knowledge. But actually, our research has shown that we have made a lot of progress in bringing together international biodiversity and human rights law in relation to the first and second objective of the convention, in relation to conservation and in relation to the use of natural resources. And even more, we are aware that the convention has played an important role and maybe has been even pioneering in addressing the question of the recognition and the respect and the use of traditional knowledge. And there may be more that the convention could do with regard to the production of knowledge more generally. And you may think of global processes to understand environmental challenges. So there is a role there for the convention that maybe there's a potential that hasn't been fully realized yet. Another question that maybe hasn't received as much attention is that of the human rights of the general public. We don't really discuss very much and very explicitly how the convention links to access to information, public participation in decision-making, and access to justice, and how all of us may have a stake and an interest in how decisions on biodiversity are taken with a view to also protecting and realizing our human rights. And this is just to show, to give a sense of how much and how far we've gone with the cross-fertilization between international biodiversity and human rights law, with specific regard to indigenous peoples and local communities, territories, lands, and resources. And this is just to show that the three key pillars for protecting indigenous peoples' rights to their territories and lands and resources are very familiar concepts in the context of the CBD. So we have environmental and sociocultural assessments, free prior informed consent, and fair and equitable benefit sharing. And what I want to show here is just that particularly the Inter-American Court on Human Rights, but also other international human rights bodies have relied time and again on particularly the CBD AQUECON guidelines, but also other instruments such as the Work Program on Protected Areas or the Work Program on Forest Biodiversity to really explain how these safeguards, international human rights law safeguards, apply in practice and in the context of planning processes, natural resource licensing processes, and processes that are more familiar to maybe environmental practitioners than human rights practitioners. And interestingly enough, this cross-fertilization has also been picked up, not only thinking about the role of governments in protecting human rights in the context of decisions related to extractive activities, but also with regard to the role of the private companies and what is emerging as a clearer understanding of the responsibility of business enterprises to respect human rights. So what has happened is that several different sources have used, again, the CBD AQUECON guidelines and other decisions adopted under the CBD to explain what steps business have to take to respect the rights of indigenous peoples to their lands and resources. Now, there's still a lot of questions open about this cross-fertilization, and I only want to highlight a couple of points that are relevant for our reflection today. I mean, one is that the advantage of thinking more about the relative strength of these two areas of international law is very significant. So the fact that human rights standards rely on the CBD also means that when CBD parties undertake activities to implement the convention, they also have to keep in mind human rights standards. And that really affects the choice of the means of implementation under the CBD, which is left very broad in CBD terms. So not any implementation of the convention is acceptable if we take into account that also relevant human rights standards have to be respected. And that really has to do with identifying a minimum content of state obligations, minimum expectations that we have vis-a-vis what the degree and the type of steps that will be taken to implement the convention, with a view to avoid any infringement, resulting infringement of human rights. And that also means that the means to be used are, from a human rights perspective, are very specific. We need national laws that spell out what the obligations of the state are and different state entities, and what obligations business enterprises have in a domestic context. So not any other means would fulfill in the same way the human rights law requirements than national law. And then, of course, there's the question of access to remedies and really providing access to justice for those that are negatively impacted by activities related to conservation and sustainable use of biodiversity that may have impacts on human rights. And these, again, are issues that are generally not specifically addressed under the convention, but for those states who are willing and able to fulfill their obligations under both the convention and relevant international human rights treaties, this is very much a key matter to keep in mind. And at the same time, the convention itself provides the element of concrete guidance that generally we don't find under international human rights law. Human rights law remains to a certain extent quite abstract. And the CBD, because of that also exchange of experiences across all the stakeholders that participate in the CBD processes, has been able to distill very concrete lessons learned and good practices that really guide specifically step-by-step different actors in taking into account human rights concerns, again, not necessarily using human rights language, in the context of conservation and sustainable use. Now, we normally look at those steps as safeguards in a protective manner, let's say, but again, I think there is a potential there to be explored moving forward post-2020 into how these CBD guidelines can actually be used proactively to think about fully realizing the rights of indigenous peoples and local communities and other relevant human rights. So in a way, to have a more strategic and systematic engagement between the relative strength of international human rights law and international biodiversity law, and really looking not just at protecting rights, but their full realization. Now I'm going to move on to the second part of the presentation, which is really to try and distill key messages that have arisen mainly from the work of the UN Special Rapporteur, Professor John Knox. There's 3 reports that I think are particularly relevant for our purposes, and just a couple of points that I wish to bring to your attention with a view to then explain how I see this as promising leads for thinking about a post-2020 biodiversity framework. I mean, the first is that recognition that without effective biodiversity conservation and sustainable use, we will not be able to realize our basic human rights. And we don't need any new international law to tell us that. In fact, what John Knox has clarified is that already with the international law that we have, even if, as I said, maybe the language used under international human rights law and biodiversity law is different, we already have a very clear understanding that the protection of biodiversity is a matter of international human rights law. And we have both substantive and procedural obligations in that connection, and heightened obligations when particular vulnerable groups are at stake. And that's, of course, the case of indigenous peoples and local communities, but also other groups such as women, people in poverty, or children. And so what John Knox has done as the culmination of his work as Special Rapporteur has been developing framework principles that really distill where we are at the intersection of international human rights and environmental law today as a matter of law. He also acknowledged that maybe not all countries may necessarily agree with all of his principles, and there are differentiation among the binding legal obligations on certain countries, depending on which treaty they are party to. But he said that there's a lot of convergence across the world on these principles, and all states should consider those principles as best practice that should be adopted as expeditiously as possible. And there are one principle in particular, Principle 15, very much encapsulates that evolution that I mentioned in a previous slide about the relevance of the Convention on Biological Diversity in relation to environmental assessments, free prior informed consent, and benefit sharing. But other principles are also relevant and have benefited from the work of the Convention. Now, before this report, actually last year, John Knox also published a full report devoted to the relations between human rights and biodiversity, and I was quite privileged to be part of the expert group that advised him on that work. Again, there are very important elements in that report. They don't change the law, but they clarify what the law is today. First of all, they clarify that ecosystem services are one of the things upon which our fundamental human rights to life, health, food, and water depend upon. And because of that, biodiversity loss or degradation has human rights implications. So when we speak about human well-being, and you find several references in the context of the SDGs, as well as in the current biodiversity strategic plan, we are actually talking about general human rights obligations. Human well-being translates into those basic human rights to which we are all entitled to. And in addition, we have, as I was saying, heightened human rights obligations in relation to vulnerable groups, and that brings a dimension of non-discrimination, which again maybe needs to be more explored in the context of the Convention. And importantly, this plays out when we find ourselves in a balancing situation. As we know, often questions of conservation and sustainable use lead to a balancing act of economic, social, and environmental impacts. Now, this balance is not a balance that's free from international benchmarks, and human rights provide those benchmarks. So it needs to be a reasonable balance where we can't have unjustified infringements of human rights that could have been prevented. And that really means that, again, when we're thinking about sustainable use, that becomes an important benchmark for decisions to be taken in a particular context. And of course, this is not just something that each state has to do for its own, but matters of international cooperation, which are very much also essential for biodiversity conservation and sustainable use to occur in certain countries. Cooperation has also human rights implications, and shortcomings of international cooperation that lead to biodiversity loss have human rights implications of their own. The last report I want to discuss very briefly is also a report from this year, in which John Knox explored particularly the importance of a healthy environment for the realization of the rights of the child. And I think that that really provides key pointers for the biodiversity community. We probably all know that children are the most vulnerable group to environmental harm, and this is because they are still developing physically, and they're also less resistant to many types of environmental harm. And I think that the insight there is that really makes us think about the importance of intergenerational equity, something that we know we all strive towards as part of sustainable development, but we hardly ever address in explicit terms. And one example of how we can be explicit and concrete about this is what John Knox has suggested in terms of public participation. We need to provide opportunities for children's views to be heard, particularly when decisions have to do with long-term impacts. And biodiversity loss is one such area where decisions need to take children's views into account. And I think as part of that, the legal, power of this consideration is that in all matters concerning children, and if we all agree that biodiversity is such a matter, then the primary consideration needs to be the interest of the child. And that really may allow us to think much more in the long term. And again, thinking about that reasonable balance, it really forces us to look beyond the short term, maybe in a more vivid way than abstract concepts of future generations that are still to come. And the final point I want to make on relevant international human rights processes is something that other colleagues have already discussed in the previous webinars, but just the understanding emerging time and again from the Human Rights Council and other important human rights processes, that the Sustainable Development Goals and the 2030 Agenda are grounded in international human rights law. Their implementation needs to be consistent with relevant obligations related to human rights. And actually, the agenda itself seeks to realize human rights for all. So in a way, we can't really speak about the SDGs without bringing in that human rights dimension. So as we move to the final part of my presentation, then the question is, how do we, as thinking about the role of the Convention and a post-2020 biodiversity framework, how do we engage with the 2030 Agenda in a way that lives up to that understanding that the agenda is grounded in human rights and needs to push for their protection and full implementation? So I think there are at least 3 entry points currently open under the CBD for us to think about these questions and maybe look at this issue from different perspectives. First of all, at the previous SABSTA meeting last year, there was an understanding that we should work towards a long-term strategic approach to mainstreaming biodiversity into different productive sectors and with a view to implementing the 2030 Agenda. Now, this, of course, means that also in mainstreaming biodiversity and thinking about how that may affect sustainable mining as opposed to sustainable energy production and so on, means that the human rights linkage needs to come with that mainstreaming. But it also means that for the biodiversity community, engaging in mainstreaming, it's not a one-way process. It really needs to be a mutual learning with other colleagues working on the 2030 Agenda, and they may have their own contributions to make in relation to how we protect and fully realize human rights in that work. The second pathway is to do with the work on Article 8J, which is the main legal basis under the Convention to work on indigenous peoples and local communities issues. We have a process now started of thinking about future arrangements. So both the process and the content of the work, they should be undertaken under the Convention, once again, taking into account the 2030 Agenda. And I think, to me, one of the key concrete questions for the process and the broader biodiversity policy landscape is how we can effectively and respectfully integrate traditional knowledge across all the work we do internationally on biodiversity, and taking that knowledge on the same level of understanding and respect that we have for other sources of knowledge and science. We have started on these points, both within the Convention and also in the context of the Intergovernmental Platform on Biodiversity and Ecosystem Services. But of course, that is a long road, and we still need to put a lot of effort, genuine efforts into that. And finally, of course, as Bala indicated at the start of this session, we are working towards laying the ground for a follow-up to the current strategic biodiversity plan, and particularly thinking about synergies, trade-offs, and limitations to identify effective policies to achieve the SDGs. So again, thinking about human well-being as an international human rights matter means that maybe we have to change how we have framed the role of biodiversity and of the convention in the current plan. And so I move now to my conclusions, and I hope that they will spur a good discussions after the other presentation. I mean, the first question, thinking about sustainable use in the post-2020 framework and in the context of that growing understanding of the relationship between human rights and biodiversity law, is that sustainable use also means use that does not lead to unjustified, foreseeable human rights infringement. And what that means, again, concretely, is that we need to do more work on environmental assessments, both at the impact project level as well as the strategic level, and really thinking about the broader role of ecosystem services for everybody's well-being, as well as pay particular attention to vulnerable groups. And that means maybe engaging more in disaggregated data about different effects on different groups. The second point is what I was mentioning earlier. There's a lot of potential and I think a lot of responsibility to protect and fulfill the rights of children, and keeping in mind that children's best interest should be a driving force in our understanding of what the long-term vision of sustainable use, according to the definition in the convention, really means. And finally, I think a reflection that is only partially developed, but maybe colleagues on this webinar may be able to provide ideas, is that I think at the moment we're thinking about the targets and a new strategic framework, very much separating the what from the how, separating targets about the status of biodiversity and the benefits that will arise from protection and sustainable use, and how we will achieve them. And often among the how targets, we have this indication of public engagement. And I think we have to be careful there that the how matters almost as much as the what. And the coming together of international biodiversity and human rights law means that how we pursue conservation and sustainable use is not just a matter of process or good process. It's really about finding long-term sustainable solutions where, in a way, we are really speaking about elements that are already present in the convention. And so the social dimension of the ecosystem approach very much reflects the concerns that we have if we think in human rights terms. But at the same time, we may need to think maybe more, again, more strategically about the full potential of the convention to take into account human rights holders, and also to distinguish where duty bearers are. And that not only includes governments, but also business and financial institutions. And I think the role of those actors in the context of sustainable use is, of course, crucial, and maybe being more strategic and systematic about how their work on conservation and sustainable use can affect human rights positively or negatively would be an important legacy moving forward. So I'll close here just to say that I think that there are, of course, principled arguments about this relationship, legal arguments, but there's also strategic opportunities to really bring the urgent need to protect biodiversity into everybody's hearts and minds, to think about policy coherence and legitimacy of interventions under the convention, and maybe to address these questions with more priority and new allies that can be found in the human rights community, as well as in other communities that maybe are more advanced in their interaction with human rights than the biodiversity community. So thank you very much. And all the references in my presentations are also available on our website. So I look forward to discussing these ideas with you.
Thank you, Elisa. Thank you very much for a brilliant presentation. I've touched most of the points that we discussed, but also we would like to discuss in the context of the post-2020 process under the CBD. I'd like to invite Harry Jonas to take over and make his presentation, please. Harry, over to you.
Thank you very much, Bala. I'm just setting up here. Great. So, friends, thank you very much for this opportunity, particularly to MBSAP Forum and Fledge and some of the other partners such as Swed Bio. Let's move this. That's better. So yes, thank you, Eliza, who has set things up really, really nicely by providing those overviews and looking ahead. I've been involved. I've listened to the 3 webinars as overviewed by Bala just now, and you know, there's what's obvious is the law is developing, increasing numbers of partners are coming together, and ideas are being wrought. What I'm going to present on is 3 initiatives that natural justice and partners are involved in that are drawing on this body of law to promote local to national to global justice. And so, yes, that is what the 3 initiatives that I'll be presenting this evening. As a kind of brief introduction, natural justice was involved in a series of legal reviews, 15 national level legal reviews, looking at how the law supported or hindered Indigenous peoples and local communities against various impacts. And from across all 15 countries, the same core impacts emerged: globalization writ large, climate change in various ways, forms of industry such as agriculture, extractives, and infrastructure, and also, to some people's surprise, not mine particularly, but some people, also conservation initiatives, undermining and negatively impacting Indigenous peoples and local communities. And so, to show you where we'll be going in this presentation, the first 2 initiatives are sectoral. They're very much focused on conservation initiatives as they relate to Indigenous peoples and local communities' human rights. And the 3rd initiative is systemic, and clearly isn't trying to deal with all of these issues comprehensively, but addresses them in a cross-cutting way. And I'm happy to be able to say that the presentation does come full circle, almost exactly to Eliza's first slide. And so that should be a happy place to end and launch some discussion. Okay, so as an introduction to the 1st and 2nd initiatives, I'm going to give a very brief overview of the relationship between human rights and conservation. I'm sure many of you are fully conversant with these issues, but just in case anybody's on the line, I've just got a few slides to introduce the issues. It's a gross overstatement, but I will make it anyway, that something like the essence of 20th century conservation was a push to establish protected areas. The concept being we need to save nature from people. It's an idea which is an important idea, and it served a good amount of biodiversity very well in some extraordinary protected areas around the world. Unfortunately, however, that approach has had negative impacts on some Indigenous peoples and local communities around the world. I was privileged enough to live in the Kalahari for a few years, and this is, well, there are a number of groups, but broadly they're described as the San or the San Bushmen who live there. And these are some images from a community gathering they had. And these communities live very, very closely with nature. They depend on it, and their culture, their whole identity is interwoven with the Kalahari. These communities have suffered extraordinary levels of injustice. There's a whole range of them, a very wide range of them over a long period of time. Unfortunately, being excluded from a conserved area, it's called the Transfrontier, Kalahari Transfrontier Park, is one of them. And when these things happen, or all these different things come together, they end up living, this is on the outskirts of the town in which I lived, in some quite rough conditions. And one of the things about these kinds of injustices is they have generational and multi-generational effects as well. This is a family I got to know very well. and they have knock-on. They have direct effects on the people, and they have knock-on effects on the generations that follow. To give you a scale of this issue, Natural Justice teamed up with IIED for a good 4-year stint of working on these issues, and a sort of a rapid review of a couple of researchers that IIED found online, simply by just looking online, 35 active and highly publicized conflicts that were happening at that time. Let's call this 2014. What's interesting is when you look more deeply, as the Rainforest Foundation UK did at about the same time, in the Congo Basin, they found that out of 34 protected areas, 25 of them had some level of conflict within or around them. As mentioned already, we've got UN Special Rapporteurs. The UN Special Rapporteur on the Rights of Indigenous Peoples, Vicky Towley-Corpus, wrote a report exactly on this issue 2 years ago. And she found that in Latin America, for example, 90% of protected areas have been designated and established on the lands of indigenous peoples and local communities without their consent. And when these things happen, as you can see down further down the page there are a range of injustices that this leads from and leads to. I won't go through them all, but you can have a look at them there. And when these things happen, they impact directly on indigenous peoples' right to self-determination, present tense and future tense. So Natural Justice is certainly not working alone on this, and I'd like to certainly mention Swed Bio, that's been very involved in this Forest Peoples Program, as two of the NGOs working alongside a whole range of different indigenous peoples and local communities, organizations. And the kind of theory of change that we collectively have, even if we don't necessarily articulate it to each other exactly like this, is threefold. And I'll speak about the first initiative I'm going to speak to, speaks to the first two of these issues. And then I'll get to the third one later. So we need to do at least two things in the first instance. We need to address existing injustices through judicial or non-judicial mechanisms. Non-judicial redress mechanisms, obviously. And then we need to stop future injustices occurring within the current conservation model, i.e. within the context of protected areas. And so that brings me to the work we're doing in our first initiative. And that is, we are working broadly to constitute a human rights and conservation framework. So let me explain a little bit about this work, therefore. Okay, so throughout this webinar series, we have heard very, very strong presentations on the level of law that exists. We have got an extraordinary amount of international laws and policies, and you just heard Elisa saying, you know, we don't necessarily need more and more, but we need to understand and implement this body of law more effectively. I couldn't agree more. We have got the UN Special Rapporteurs, their reports, framework principles, as you've also heard this evening. We've got judicial and judicial, and the third bullet point, and non-judicial mechanisms as well. For those of you who don't know it, the Whakatane mechanism is an IUCN Forest Peoples Program brainchild, and it's a non-judicial dispute mechanism directly designed to deal with conservation disputes. I'm a great fan of it. I'd like to see it do even more than it's doing already. It isn't being used enough, essentially, for various reasons. And we also have a range of these things, including something Natural Justice has produced called the Conservation Standards, where we set out the UN Declaration on the Rights of Indigenous Peoples in the context of conservation initiatives to make that document, the UN Declaration, supremely important document, just more digestible for people who are not necessarily conversant in the world of human rights, but are involved in conservation. So we have a whole range of these elements, but as you can see there, highlighted in orange, they operate independently. And so one of the proposals that I've made and we plural are kind of discussing at the moment is how do we turn what we already have into a functioning unit? So simply put, all I've done there is brought the elements forwards and shown that they can simply become the evolving human rights and conservation framework if we so design it, and if the actors involved, and I'm talking about everybody along the chain from funders to UN agencies, to governments, to conservation agencies, indigenous peoples, local communities, NGOs, etc., want to see this happen and start understanding these things as a framework as opposed to completely unrelated and probably largely ununderstood kind of elements. And one of the questions, if we were to go down this route, we're asking ourselves is, do we need a secretariat for something like this? There are models out there. Of course, there's the Roundtable on Sustainable Palm Oil. There's a range of different things like that that we could look at. Do we need to have a secretariat? If so, does it have to be, a group in a building, or can it be much more mobile, much more sort of 21st century people who are working on this issue, give some of their time, focus on it, etc. So that's the first initiative, and as you can see, it is a work in progress. And the latest update on this is that this idea has been included in a report produced by 2 expert members of the UN Permanent Forum on Indigenous Issues that is happening this week in New York. And now, basically, as we speak, there is a dedicated session to further discuss the report, which has already been presented. And colleagues of mine in natural justice and other organizations, including SWEDBio, Forest Peoples Program, and obviously all of our indigenous colleagues will be actively engaging on this and trying to sort of divine what should be the next steps. It's an active conversation. One of the proposals we've made is it would be useful if we did get our skates on, depending on, whatever we decide, to undertake those activities in the next 2 years. And we have got in 2020, not only obviously the supremely important CBD COP15 in China, but we've also got the upcoming IUCN World Conservation Congress. And at least having some progress, some very meaningful progress on this issue and presenting it and further discussing it and looking ahead would be, I think, very sensible, and it would bring us into a lockstep with CBD processes and IUCN congresses and things like that, which help. Okay. So let me just recap. In terms of our theory of change, we're trying to address existing injustices. We're trying to stop future injustices through the first initiative. But friends, that isn't enough. It's not enough, I think, just to remain in the current lockstep. It's important to innovate on the existing framework, to create, hopefully, a better, more enabling environment for respect and cooperation between all of us. And that is the focus of the second initiative. So, I apologize for the gangly term. It's a negotiated term, and I'll explain that just now, but we also abbreviate that to the acronym OECMs, and increasingly, we are using the term conserved areas as a short form for other effective area-based conservation measures. Let me now talk you through this. Right, as we on this particular call are all very aware, we agreed that Aichi Biodiversity targets 20 of them in 2010. Target 11 calls on parties to conserve 17% of terrestrial areas and 10% of marine areas through protected areas and other effective area-based conservation measures by 2020. And I was doing some research on this, doing some work and thinking around this in 2013, and asked myself and subsequently colleagues, probably including Elisa and others, what are other effective area-based conservation measures? Where can I find a definition? Where can I find guidance? Who's working on this thing, etc.? And the answer was that it wasn't really happening at all. And I, particularly in the context of what I've explained and where I was living and some of the work, obviously, that I've been doing, I started wondering to myself, you know, surely in the phrasing of Target 11, without sticking slavishly to it, but just interpreting it, surely OECMs or conserved areas must be areas that are not protected areas in the way it's written. And surely also they must be leading to the conservation of nature, of biodiversity. And I wrote a piece that suggested that the World Commission on Protected Areas undertake some work on this, and subsequently a task force was established on OECMs, and I was asked to co-chair it with the chair of the WCPA, Kathy McKinnon, and we have been having a very, very interesting time working to develop a definition of other effective area-based conservation measures, and also to develop guidance on that. And the task force has got over 100 experts working away on this, and we've had a whole range of meetings. All of that is online. If you'd like to have a look, you just Google OECM's IUCN and you'll find all the information, or of course write to me. But just to skip to the heart of the matter, rather than talking too much about process, the easiest way to describe where we've got to with our draft definition is the following. The IUCN definition of a protected area is very focused on intention. It's a very intention-based definition. A protected area, as you can see here, is an area that is dedicated and managed to achieve the long-term conservation of nature. It's the crux of it. So an area, to qualify as a PA, must necessarily have a primary conservation objective. Its primary conservation objective must be the long-term conservation of nature. Okay. And working through the task force, through the many, many meetings we've had and CBD deliberations and inputs from the parties as well, we have got to a definition of OECMs where the crux of that is that they should deliver the effective conservation of biodiversity, but importantly, they don't have to have a primary management objective of being for conservation. And of course, they should not be a protected area. So not be a protected area, they must conserve biodiversity, and it doesn't matter how they're getting there. This is normally the point where I would ask the audience whether everybody's following, but I can't do that in this context. I hope that's clear enough. And so what's really interesting about this is that, yes, we've been working, for example, with BirdLife International and other partners, looking at key biodiversity areas. So we've looked, or the researchers who've done this have looked at 607 KBAs that are not protected areas. I mean, just to absolutely underscore, an area cannot be a PA and an OECM at the same time, okay? So we're looking at key biodiversity areas that are not protected areas in these 8 countries. The findings are very, very interesting, and I've just pulled out the kind of headline one, and that is to say that 75% of these areas have management systems consistent with the evolving definition of a conserved area, which you can imagine in these megadiverse, I think, well, mostly megadiverse countries, is is a very, very interesting and compelling story. And when you look more closely at the governance of these areas, you can also see that it is if you look at the bottom quarter, you can see that at least 25% of that, at least 25% are governed by local communities and indigenous peoples. But you can also see that the governments are governing a significant amount of these areas. And in 2 slides time, I'll give you a very good example of that. Private areas, spiritual related governance structures, certainly, you know, religious organizations and others. That's interesting. And as a result, when you look at the management objectives of these areas, you have got a smorgasbord of different, so we can work around. I just want to draw your attention to the top right blue, if it's showing up nice and blue on your screens. Business activities, mining, oil extraction. It may be that the final guidance that's developed and agreed at this upcoming CBD COP will exclude intense extractive industries from conserved areas. So I'm just putting a question mark over that. But as you can work your way around, you can see that there's conserving nature for various purposes. We've got government activities, and the largest segment there is preserving ecosystem services, which then accords with what Elisa was presenting on, and an area of work that she's particularly interested in. As well as, when you keep on going, religious and spiritual values and livelihoods is also obviously a major aspect of what you can see there as well. So suddenly the conservation paradigm changes, I think, significantly, perhaps even radically, when you bring in these kinds of areas and start recognizing them. Bala, this slide is specifically a gift for you. I am just back from a meeting of the WCPA, where we discussed, amongst other things, conserved areas. And there was a presentation by the director of the Wildlife Institute of India, who, this is drawn directly from his slide, to say that, okay, there are 638 terrestrial protected areas in India, covering this extraordinary amount of land. But in percentage terms, that amounts to just under 5% of India's forest and non-forest areas. Okay, that's the first statistic. Then let's focus in. If you then look at the forest areas outside of these protected areas, so not including those protected areas we've just mentioned, that amounts to another 17% of India's geographical area. And so I have seen, but certainly not across all of India, and as I have been updated by the director, many of these areas are used for one kind of local livelihood generation, non-timber forest product livelihood generation, or another. And these areas are therefore both very important for livelihoods, but extremely important for biodiversity, not only per se, but also connecting the protected areas and a whole range of other things. And again, the suggestion is that many, if not all of these areas, at least prima facie, would qualify as conserved areas, what we're terming in our guidance as potential conserved areas, categories of areas that look promising, but of course would need to be assessed at the local level. So coming back around from what I've been saying, let's borrow from that, and let's look again at the post-2020 biodiversity framework and beyond. There has been some very impressive work by parties towards the numeric targets under Target 11. Our good friend in the Secretariat, Sarat Babugida, suggests, and I agree with him, that it's likely because of the numeric targets that countries have focused so much. And I wonder if we don't see more numeric targets working their way into the post-2020 biodiversity framework as a result. But focusing in on the issue at hand, OECM's conserved areas, I believe, offers a momentous opportunity to innovate on current conservation models at the international and obviously at the national levels, particularly in two ways. In the first instance, as you saw from those pie charts, it promotes recognition and support for areas important for biodiversity, beyond national biodiversity, national PA systems, and also it brings in this great diversity of different players and actors who are through their actions conserving biodiversity, but aren't necessarily getting either the recognition or the support for that. And I certainly think we should be doing that. And then the final issue, most dedicated to the point I've been making about conservation injustices, because you don't have to recognize an area as a PA, and because you don't have to make it oftentimes a complete no-go area for indigenous peoples and local communities, and as a result, as I say, in some cases infringing their human rights, you can recognize and give support to what's working now locally without changing governance systems and forms of management, etc., and instead support and very much support those existing frameworks today. So that, friends, is the second initiative, as I said, a more sectoral initiative. And now we broaden out, to the third initiative. And this initiative, we are dubbing Target 21. I'm happy to go on record to say simply because giving it a name, I think, will help it get picked up by people. And I very much like your comments on the first two initiatives, but I would say I'd particularly like your comments on this third initiative. And this is just 3 or 4 slides, so I'm close to finishing. So here we are, Aichi targets and the SDGs. We, as we all know, have got 20 biodiversity targets. But here's the point: even though good governance is critical to each one of these targets, as you'll know, we definitely don't have a dedicated target. We have got good governance and aspects of that mentioned throughout each one. And I think that's an important way to go. I don't think that we need to jettison that approach. The question that a few of us are now asking, including Claudia Duarte Lima, who mentioned this in the very first webinar, is, this contrasts quite sharply now, actually, with the SDGs that have, as you can see there, Goal 16 on peace, justice, and strong institutions. Have a read of that closely. It's heartwarming, I would almost say, in terms of the clarity of what is being called for there. We don't have something quite as clear in the biodiversity targets, and Elisa, in her presentation just now, was also speaking to that very clearly, actually, that even though the issues are there, they're not as explicit as they could be, or perhaps should be. And so here, the final bullet point, you can see we're putting this on the table, considering the importance of good governance and human rights to the post-2020 biodiversity frameworks. Shouldn't we include a dedicated target on good governance, aka Target 21? Right, actually, before I get to this and you start reading it, I was on the plane today, and I just decided I'm just gonna write something, not because I think this is what the target should be, but because I thought I would be, it would invoke some discussion if I did put something down. So you could say, probably, well, I wouldn't write it that way, I'd write it this way, and already we'd have a conversation. So yes, from my rather small seat, this is what I produced. Target 21 on good governance of biodiversity. Oh dear. Okay. Right. Looking at the text itself, by 2030, the governance of biodiversity is conducted in ways that are in accordance with human rights standards ensure the full and effective participation of all relevant sectors of society. Related decisions are transparent and their implementation comprehensively monitored and reported. There are accountability mechanisms in place that include effective means of redress, and all relevant information is freely and easily accessible. And so, whilst I'm, as I say, underscoring, not suggesting that this is the text we use, I guess rereading this to myself now, the question I would ask myself is, why wouldn't we have something like this in the post-2020 framework? Why would anybody argue against all of this? Or if the issue is with particular words, perhaps human rights, perhaps a couple of other things in there, then let's have that discussion. But it would be very interesting to hear collectively if anybody thinks this is not a useful suggestion at all, especially considering the linkages with SDG 16. Okay, so very, very super brief conclusions. It's just actually a summary of what I've said, and that is to say, what I've talked you through is drawing on this great body of law, policy, and reports and other things that are out there that have been presented through, I think, a very, very engaging series of webinars to try and draw on and illustrate as well how we can use this law in a sectoral manner in the context of conservation and human rights, and in a more systemic way vis-a-vis the post-2020 biodiversity framework. Thank you very much. Please be in touch. I put this up there because I have been and am very much with natural justice, but as Bala explained, I will be starting a new organization called Future Law, and you can get me on either of these two emails. Thank you.
Thank you so much, Harry. Bala, over to you. Bala, can you hear us? All right. Well, I know Dr. Pisupati wanted to share a couple of remarks after Harry's presentation. But in the meantime, I'd like to, there's a little hello from Asghar Khan to Dr. Elisa. So I wanted to share that with you. And we have a question from one of our attendees. So unless Bala, if you wanna join us right now and share your remarks, I'll go with Victoria Collins, who raised her hand a while ago. Okay, Victoria, I will open your mic. Hello, Victoria, good morning. Victoria, can you hear us? Victoria Collins? All right. Nothing there. Bala, are you back?
Hola, Eva. This is Diego. I would like to ask Dr. Bala that unmute the microphone. Just right-click on your name and then look for unmute the microphone, because I can see his microphone works, but I'm not sure what is going on with the connection.
Bala, can you hear us?